Good morning, and welcome to Day 10 of Nevada versus Duane Keffe D. Davis in the Tupac murder trial. Duane Davis accused of orchestrating the murder of the rap legend here in Las Vegas, in the streets of Las Vegas, in September of 1996, almost 30 years to the day. The prosecution has rested. The defense has rested. Today, on Friday, here at the end of August 2026, the lawyers will discuss with the judge the jury instructions that the judge will read to the jury on Monday morning before closing arguments and before the jury goes to deliberate this widely watched, very confusing trial of Duane Davis. There you see him in the middle of your screen. Duane Davis yesterday giving a thumbs up to the people behind him inside the gallery. You see him there sort of clapping his hands. He looks back. His son was behind him. He gave a thumbs up. We can see a little excitement there. He had two witnesses, or three, but two in particular, testifying about seeing a white Cadillac leave the gated residence of Suge Knight, the founder of Death Row Records. Suge Knight was in the car. There he is, Suge, the founder of Death Row Records, at some point a $300 to $500 million entity, of which Tupac Shakur was perhaps its biggest star. And there's the rap legend himself, who died at a very young age in cold blood back in September of 1996. He was in a BMW with Suge Knight, but what the witnesses, two Metro cops who were at Suge Knight's house the night of that Mike Tyson fight at the MGM, there's your last picture of Tupac ever taken with Suge Knight in the car. Those officers said that they saw a white or cream-colored Cadillac leave the estate, and shortly thereafter, the rap legend was dead. But here's the thing. The prosecution's theory is that it was Keffe D in a white Cadillac who shot or who orchestrated the shooting of the killer, that Keffe D's nephew, Orlando Anderson, is the one that riddled that BMW with bullets. And let me tell you, that was surprising. Two people who have no skin in the game, in the sense that, you know, one would think law enforcement working for the Las Vegas Metropolitan Police Department, testifying for the defense. What could they possibly have to say that would bolster Duane Davis's defense? And what it was they entered what could be the only or a second white Cadillac into the conversation. And I thought that was shocking, because during the week plus of testimony of prosecution witnesses, we heard no real evidence that Duane Davis was in a white Cadillac, even that Duane Davis, Keffe D, was in Las Vegas. Not one receipt, not one person to say, yes, I saw him here. Yes, I was with him. Keffe D, not in any security video in the MGM the night of the Mike Tyson fight, or in the aftermath when the let out happened and his nephew, Keffe D's nephew, Orlando Anderson, was beaten down seriously by Suge Knight and 20 or so Death Row Record security guards, and the rap legend himself, Tupac Shakur, in a green shirt, seen there kicking Keffe D's young nephew, who is said to be the gunman, by prosecution theory, of this shooting that changed the rap world forever, that has drawn the attention into Las Vegas of the gang world, of the music world, of Death Row Records, of celebrity from all shapes and sizes. Names have come up in this case: Mike Tyson, Justin Bieber, Sean Puffy Combs, many. Look at that fight. And there's Puffy himself with another rapper who looms large in this case, Biggie, Christopher Wallace, who it was the investigation into Christopher Wallace that led authorities to interview Duane Davis, Keffe D, under a proffer in which Keffe D, I believe, thought he would never, those confessions or admissions would never see the light of day. It was the investigation into that death of Christopher Wallace that law enforcement, we heard in an interview, we saw the transcripts and heard the audio, that Keffe D came in to discuss the murder of Biggie and said, oh no, we didn't do that one, we did the other one. And they said, the Tupac one? And he went on to explain in great detail what he says happened. It was a similar version, although not exact, to what he wrote in his book, Compton Street Legend. And it all comes down to who you believe. And in fact, we have a clip, just in case you haven't been watching. this is what the jury has to consider: are confessions like these some of what is going to put Duane Davis behind bars for the rest of his life, or is it not enough? And here is a listen to one of those confessions to law enforcement back in the 2008-2009 era in Soundbite H.
Here they come in that BMW, like gang of cars, and brawls, Tupac, Tupac. And we like, there they go. Made a U-turn. We wasn't supposed to make a U-turn. We just wanted a U-turn. And they was in the middle lane. And we just pulled up on the side and checked every car to see where they was.
So what directed your attention to him was some girl shouting at Tupac?
Tupac. He gave himself away. Otherwise, they would have got away. He all hanging out the window. You know how he do. Oh, they go down the fish. And anyone got him.
You did a U-turn, so then you pull alongside of it. You guys are in the car. Have you already handed Lane the gun at this point, or at what point do you hand him the gun?
I thought he was going to pull on my side. You know, that's my little nephew. I'm going to look out for him, you know. And he pulled on his side.
So you were fitting to blast if you had to, or you were just...
Yeah, if we would have been on my side, I would have blasted.
Okay. So you hand the gun to the back seat.
Yeah.
You can hear Lane.
I gave it to Dre, and Dre was like, no. And Lane's like, you pop.
So Baby Lane, Orlando Anderson, is Keffe D's nephew. And he's saying that after the Tyson fight and Orlando Anderson got his butt kicked there in the floor of the MGM by Suge Knight, Death Row Records security, and Tupac Shakur himself, that they went in search of Tupac to Club 662 to try and find him. They went to look for him. They were unable to figure out if he was inside of this club, and they went to on with their night. They went to a liquor store, he said, and as luck would have it, Las Vegas is an area that they were in, not being tremendously big. They went to the liquor store and they were driving, and they said they saw Tupac Shakur hanging out of the BMW talking with some fans. That's where he says, Tupac, Tupac. That was the adoring fans, and there's the picture of him in that BMW. We had a witness testify that she was behind that car and did not see him leaning out the window. And then another close associate of Tupac's, Edie Amin, a rapper who was part of the Outlaws, musical connection with Tupac, and an alleged mentor of this Edie Amin, and a family member. He said he did see that. So there's some corroboration there. There's some that takes away from that testimony, but ultimately, Keffe D telling law enforcement that he in fact saw that, told the car to turn around, and when they got up next to the car, he threw the gun in the back seat. The man closest to the window didn't take it, but his nephew, Orlando Anderson, who ultimately died not too long after in a shootout at a car wash, did, in fact, shoot and kill the rap legend. And that same Edie Amin testified that he saw a arm reach out of the window and the gun attached to it, and saw the shooting. He did not see the faces. And that was fascinating testimony. But so you just heard a confession and or an admission, and the jury heard hours and hours of similar dialogue with him and law enforcement, and then another similar set of interviews he did with television film crews in a couple of different projects related to the death of these rappers or the downfall of Death Row Records. And towards the end of the prosecution's case, they played actual video testimony, which I will tell you hits a little different than all the audio testimony. And in this case, it's bizarre because after trial, one day, the media, including our 8 News Now investigator Vanessa Murphy, caught up with the defense attorney Michael Sanft, who said, if you watch the clip I'm about to show you, Keffe D, Duane Davis, accused of orchestrating the murder of the rap legend here in the streets of Las Vegas, didn't seem to have a total familiarity with the facts. This is on an interview with Vlad TV on YouTube when Keffe D wrote the book, Compton Street Legend. And you can see, even though he's wearing dark sunglasses, you can sort of see a vacant stare when Vlad asks him about certain admissions he makes in the book. And the jury had to square that with all of the audio testimony they heard, and this one's a little baffling and somewhat bizarre, honestly. In letter F.
But you guys don't have any guns.
Who said that?
Well, it was in the book. Until Von Zip, came in the picture.
All right, let's. I don't want to talk about that.
Okay,
Let's skip that one.
but it is in the book.
Okay, yeah. Let them read about it.
Okay, and I guess Foxy Brown was with Zip.
Let them read about it.
Okay. Well, according to the book, which there's going to be a link in the video that you can actually order from.
That's right. Matter of fact, let me see my book.
You want to go ahead and show the book?
Yeah, let's show the book. Yeah, this is my book here. I would like you guys to buy it and get the real truth instead of from a cop or some fucking industry people, some bullshit. You getting it from the real motherfucker. So go get the book, and you can get the real truth about this whole situation. Thank you.
Okay. Well, I'm going to go ahead and read from the book passage.
Okay.
On getting a gun for the Tupac hit. While we were waiting for the valet to bring out our cars, Zip seized the opportunity and called me over to his Benz. Zip was a big-time New York player, pimp, and hustler who used to come out to California and handle his business and kick it with us sometimes. As I walked up to the driver's side, I noticed the rapper Foxy Brown was in the car with Zip. So he instructed her to step out of the car and motioned for me to jump in. Zip had a hidden compartment, and he opened up, reached in, and pulled back a 40 Glock.
Like I say,
He turned to me and said, "It's time to get the money."
like I say, get your $20 and read about that part.
Plenty of authors will say, hey, I'd like to save those good details for the book, but many of them seem to have a better familiarity with the facts than Duane Davis did, especially given how many times he's gone over them. And in the book, Vlad there in that interview asks him a few good questions. And honestly, Keffe D to me seemed stumped. So, hearing the confessions and then seeing with their own eyes, the jury, what Keffe D says when confronted with facts that are in his own book, to me was fascinating. And look, that's what the jury has to decide. There's not a whole lot of evidence here. There's no blood evidence. There's no DNA. There's no fingerprints. There were no fingerprints on the 7 shell casings that a cold case investigator told the jury was when they found those shells and investigated to see what they scientifically had. This cold case investigator opening the different vials for the jury to show them the shell casings, and there were no fingerprints. Another firearms expert said all the shell casings appear to come from the same gun, but there's no direct testimony or evidence that shows anything other than that Keffe D collected some newspaper articles and has told anybody who would listen that he did it. Well, here's the thing. Keffe D exercised his constitutional right not to testify. He was given this admonition by Judge Carly Kearney inside the courtroom on the last day of the prosecution's case before the defense took over, and the judge made sure that he understood it was his right whether to or not to testify, and he tells her with a smirk on his face that he's good in letter G.
I have to admonish you on your right to testify at this time, just so you can make that decision overnight with your attorney, okay? Mr. Davis, under the Constitution of the United States and under the Constitution of the State of Nevada, you cannot be forced to testify in this case. Do you understand that?
Yes, ma'am.
You may, at your own request, give up this right and take the witness stand and testify. If you do, you will be subject to cross-examination by the Deputy District Attorney, and anything that you may say, be it on direct or cross-examination, will be the subject of fair comment when the Deputy District Attorney speaks to the jury in their final argument. Do you understand that?
Yes, ma'am.
If you choose not to testify, the court will not permit the Deputy District Attorneys to make any comments to the jury because you have not testified. Do you understand that?
Yes, ma'am.
If you choose not to testify, the court will instruct the jury, if your attorney wants me to, as follows. The law does not compel a defendant in a criminal case to take the stand and testify, and no presumption may be raised and no inference of any kind may be drawn from the failure of a defendant to testify. Do you have any questions? Do you understand that?
Yes, ma'am.
Do you have any questions in general about these rights?
No, I'm good.
Duane Davis telling Judge Carly Kearney he's good. And, it looked like for the moment he was really listening to her. And ultimately, I imagine he took his attorney's advice to not testify. He would have had a lot of explaining to do, a lot of telling the jury, here's when I was lying, here's when I wasn't lying. I think there's a story that plausibly could be told, hey, There he is, giving the thumbs up after testimony we're going to get to in a little while from yesterday, from day 9, telling, he could have a story where he says, look, I was in trouble. I went to law enforcement to work some time off here, to get years off of my the problems I got into with drugs as a member of the Crips when he was, in the gang. And they wanted a story. I told them a story. Filmmakers wanted a story. I told them a story. They paid me. I'll tell them whatever they want. And, he got it sounds like he got some good money to give those film interviews. It sounds like he got some decent money to write with a ghostwriter who we did not hear from on the stand, those interviews. And the judge, I guess it's all moot now, but the judge explained to Duane Davis that if there's a conviction in your past, the DA can talk about it. And going on the stand would open the door to any of those, at least any problems that he had, any skeleton is in his closet, anything we hadn't heard from that wouldn't be admissible now all comes in. And with regard to convictions, it would be any within the last 10 years. Now, the jury heard this guy was in a gang. This guy was a shot caller. This guy was an OG. This guy was in charge of this band of Crips. And even though the gang detective from Compton who testified that he was a shot caller and nobody ever would have killed someone without Keffe D's go-ahead, Michael Samp, the defense attorney, said, did you ever investigate a crime where Keffe D was the shot caller? And he said no, which I found after hours of testimony from this gangland detective to be just strange, that he would spend so much time telling everybody what a shot caller was on the jury and what Keffe D's role with regard to that was, and then say, well, I actually never, out of the 1,000 cases I investigated, I never found him to be a shot caller. I thought that was very strange. But he was in this fight during the time that he was incarcerated waiting for trial. He was in a jailhouse fight. He said he was protecting himself. He has said that, in fact, law enforcement sent this person to beat him up. Well, he told Judge Carly Kearney, if he was going to testify, is this when the DA is going to bring up the fact that someone got sent to beat him up, and that is letter N.
Yes, sir.
Is that why they sent them to attack me?
I understand that's your position, that happened, but ultimately, I don't know anything about that case. I've never looked at it, okay?
Okay.
All right.
In fact, Judge Carly Kearney, they're telling him, I never even dealt with that case. Another Clark County District Court judge handled that trial and conviction and sentencing in Nevada State Prison. So part of the 3 years he would have been in Clark County Detention Center awaiting trial, Keffe D spent in prison working off the time on that conviction for the fight. All of that moot now because Duane Davis, Keffe D, on trial for orchestrating the murder of the rap legend Tupac Shakur, did not testify. And there's the icon himself. His family was in the courtroom during the trial. Keffe D's family, generally not in the trial. They had a row dedicated for his family, and occasionally a member would come. His son, for instance, was there yesterday. Our 8 News Now investigator Vanessa Murphy reported. Vanessa has been in the courtroom doing a tremendous job covering this trial, not only here on our stream on 8 News Plus. We have her every night at 7 p.m. wrapping up the day's events, but she's also giving live reports at 4, 5, 6, and 11 on 8 News Now with Denise Valdez and Vanessa Murphy. That's the one you can watch here on the stream or also on television. And Vanessa does such an excellent job. And she has given us a recap every day of her events, just for us to air here on the stream. And that events of yesterday, which I'm going to get to in great detail in the 10 minutes we have remaining before court starts today. And court today is the jury instructions. The attorneys will argue of what law the judge will read to the jury as they consider the facts that have been brought into this case through the rules of evidence. And Vanessa's update, which is must-see TV here on the stream, is letter I.
Duane Keffe D. Davis will not take the stand in his defense. The defense rests on day 9 of this trial after calling 3 witnesses, all law enforcement, 2 of them who say they saw a cream-colored Cadillac at the house of Suge Knight on the night of September 7th, 1996. One of them, a detective who was in that room with LAPD and Davis and his attorney in 2009 when Davis made admissions about the crime as he faced drug charges. Jury instructions tomorrow. That's when both sides go over how the jury will be instructed as they deliberate to try to reach a verdict, and then closing statements Monday. So this trial is moving a lot faster than was expected. I did post a video about this earlier, but TikTok decided to add some music. It was awkward, so I'm redoing the video. Thanks for your patience.
Vanessa getting into the logistics of her social media posts, no doubt from the backseat of her limousine on her way to or from court in the Clark County Detention Center. Vanessa does such an excellent job. We are waiting to see her tweets her posts on X as we continue through this trial. Nevada versus Duane Keffe D. Davis. Day 10 is going to be a short day where the lawyers just argue areas of the law as you look at the Great Seal of the state of Nevada in live pictures at what has become the epicenter of the legal war this last week or two, the Regional Justice Center, the 12th floor courtroom of Judge Carly Kearney. And so we're awaiting the attorneys and the judge to enter. The jury will not be there today. Duane Davis, Keffe D, not expected to be there until Monday when closing arguments become, because there will be no admission of evidence. There will be no case today. It will just be arguments about the law. So to piggyback onto Vanessa's excellent reporting there, the key takeaways from yesterday, other than that Duane Davis opted not to testify and the defense rested, is that two Metro cops got on the stand and introduced into evidence their belief and their eyewitness observation that they saw a white or cream-colored Cadillac leave the estate of Suge Knight here in Las Vegas after the Mike Tyson fight. Okay, well, that's fascinating because there's a conspiracy theory that has been brought up by prosecutors themselves in this case. Of course, they don't believe it as part of their theory, but that the rap icon Tupac Shakur was going to leave Death Row Records, and this might have given Suge Knight or someone in that world the reason to not want Tupac to leave and to prevent him from leaving. And there have been so many rumors, but one conspiracy theory is that it's that reason and not the big fight, a revenge for the big fight at the MGM that led to Tupac's death. And when you hear about the fact that just before Tupac died, a white Cadillac followed him out of the gated estate of this man who owned a $500 million enterprise of Death Row Records, has to give the jury some reason to think that maybe if the prosecution couldn't actually place Duane Davis, Keffe D, inside of a Cadillac, well, we have another Cadillac. So this is the first the jury's hearing about it. The first we heard about it in testimony from a Metro officer who was there at Suge Knight's house because there were going to be a lot of people, including Mike Tyson, and it's all in soundbite A. That's where it begins, A.
With regard to the vehicles that went in, did you recognize or give note of any of the vehicles that were in there?
The last one was Suge Knight's, it was a cream-colored Cadillac.
Okay. And I'm sorry, I just want to make sure. The last one that you had was a cream-colored Cadillac?
Yes.
And why do you remember that vehicle?
Just pointed out to me at the time. It was occupied by two black males.
Okay.
And I didn't know Suge Knight at the time. I was kind of, interested in, looking for Tyson at the time, and they just pointed that vehicle out to me as Suge Knight's.
Yeah. And fair to say, though, that at some time in the future, you were asked to obviously write a report on that particular issue.
Yes.
That was your officer's report.
Yes.
And in that officer's report, did you include the mention of a cream-colored Cadillac with two black male adults?
I did.
Okay. Now, after your view of the Cadillacs going into the residence, how long after that did the shooting of Tupac Shakur occur?
Probably half an hour later that they came out, and it was probably 10 minutes later Mike Tyson actually entered. It's probably another 10 minutes after he came out again, and it was probably 10 minutes after that the shooting took place.
A couple questions from our jurors. Did you notice any damage or bullet holes on any of the cars that came through the gates at Suge Knight's residence, especially the white Cadillac?
No, there was no damage on it.
No damage. Were any of the crew members carrying guns?
I didn't see any guns on any of the entourage people, no, because they were all in their cars. We all had guns.
Okay,
Uniform.
got it. Did you see the cream-colored Cadillac leave?
Yes. They all left.
Okay, when was that?
Close to 10 o'clock, I would say.
Okay.
Maybe 9:30-ish.
So late at night, a police officer testifying that Suge Knight and his entourage left the gated community in Las Vegas, and shortly thereafter, after Suge and Tupac left in a BMW, a white Cadillac in that entourage followed out, and shortly thereafter, the rap legend was dead. Whether Keffe D had a role in it, well, I guess at this point that's up to the jury to decide. But if you listen to that that direct examination from a defense witness, Michael Samp, the defense attorney, letting that fact about the white Cadillac, which came up a couple of times, sink in. You could hear a pin drop while the jury digested that information. Now, this officer, Stan Hite, was a sergeant at Metro. He was there for a full solid 30 years. He ran for sheriff in the area unsuccessfully, but his own testimony corroborated by his own report from 30 years ago, before probably anyone knew the circus that this investigation, aftermath, the deadly gang war that ensued in Compton, and of course this trial could have presented. So then as the jury let it sink in, we played you the clips of the inquisitive jury's questions. Were there any guns? How long after were there any bullet holes in the Cadillac? Was there anything that, what was the timeline from when they left till when Tupac died? Not long was the answer. And I give this jury a lot of credit. They asked a lot of questions to almost all of the witnesses, to many, many of the witnesses, multiple questions. This is a jury of 16 people, 6 men and 10 women, 12 of whom will deliberate, and 4 alternates, as they will decide the fate of Duane Keffe D. Davis. And this is coming right up around the corner. Monday are closing arguments, and either Monday or Tuesday, the jury will begin deliberation, and it's anybody's guess, because this has been a fascinating trial. A much shorter one than we expected. We were told at the beginning of trial 4 to 6 weeks when jury selection started, and it ended up being, now we're at the end of the second week of trial, 3 if you add jury selection. We were told 30 to 40 witnesses by the prosecution. We only heard from 24, I believe, and then we had 3 witnesses yesterday from the defense. But and the second of those witnesses gives equally mind-boggling testimony about a white or cream-colored Cadillac that the jury heard in letter B.
Suge and Tupac were there approximately 30 minutes, and they exited back out, followed by a cream-colored Cadillac, a compact vehicle that was occupied by 4 females, and a few other vehicles that I had referred to my officer's report on. But later on, following the time that Tupac and Suge left, Mike Tyson showed up as a passenger in a Bentley, followed by another Bentley that I believe was Don King's son. And we informed them that Suge Knight had told us that the party was no longer going to happen.
I see.
And then they turned around and left.
And at 22:30 hours is where Suge Knight, driving a black BMW with Tupac Shakur in the driver's seat, followed by the rest of the caravan, leave the residence.
Yes.
Oh, and when that white Cadillac left that guard gate, it was occupied by 2 black males as well.
Yes.
A second Metro officer in uniform that night, Charlie Mangrum, talking about Tupac and Suge Knight leaving the gated estate of Suge here in Las Vegas, and a white Cadillac following along. And we heard from the prior witness, Stan Hite, another officer at the time, that not too long thereafter, the rap legend was dead. And I'll tell you, we did not hear from Duane Davis, the defendant, Keffe D, accused of orchestrating the murder of Tupac Shakur in 1996 here in the streets of Las Vegas. But I would say 2 officers testifying that there's a white Cadillac an actual white or cream colored Cadillac leaving behind Tupac right at the time leading up to his death would probably be more valuable than the defendant taking the stand. You know, the defendant would have had a lot of explaining to do, and now just the jury gets to decide whether they're going to believe that he, in all of those confessions, was telling the truth in the many admissions that he made to law enforcement, to film crews, in a book. He told R. Vanessa Murphy in an exclusive interview that he wasn't even in the state of Nevada, and you know what? I don't think the prosecution proved that he did. So it is 9 a.m. here in Las Vegas on the last Friday of August. We are just a week away or so from the 30th anniversary of the death of Tupac Shakur, shot in cold blood at the corner of Flamingo and Koval. There he is. He was at the height of his career at Zenith. You know, who knows how far. Now, as far as the conspiracy theory goes, that Suge Knight wanted, or someone in Death Row Records wanted to prevent Tupac from leaving Death Row Records. Well, we heard from Idi Amin. He was a member of the Outlaws. He was alleged to have been mentored by Tupac Shakur, called him a family member. He said he'd heard all the theories. He was there as testifying for the prosecution unwillingly, but he was a very credible. He said he saw everything except for who came out of the white Cadillac. He did not see. He saw a white Cadillac, but he did not see faces. He did say he saw an arm and a gun come out of the window and shoot his friend, shoot Tupac Shakur. And there's Suge Knight in the vehicle. Now, in previous testimony or recordings that we heard, Keffe D says that Suge used Tupac as a shield of sorts. And then even though Suge took some shrapnel and maybe got some glass lodged in his head, that Tupac, of course, was the one who took the hits. And that was later bared out by the fact that Tupac Shakur was mortally wounded inside that BMW after it was riddled with bullets. There it is, the crime scene, so famous now, just as famous as the last living photo taken of the rap legend. Now, there were photos post-mortem that the jury watched that Tupac Shakur's family left the courtroom. Most of them left the courtroom before the medical examiner testified exactly about what those bullets did to the rap legend's body. They tore it up, and his intestines were mangled. They had to take his lung out. He was filled with blood in his cavity, in his body cavity, and those gruesome photos were seen by the jury. And during jury selection, the lawyers asking, are you going to be able to handle seeing this type of photo? I remember one woman who I do not believe made it along through the process said that she would gag if she saw that, and probably wasn't a good candidate to have to sit through that. But this jury did. This jury, throughout all of the days of testimony, was very inquisitive, very engaged, and I have no doubt that they will spend the time that this case requires. My question is, are they going to go line by line through all of the audio transcripts and interviews that they heard and read during trial? Or are they going to sit there and say, what's the evidence? What's the evidence that we have to go through? Did he speak? His spoken word going to send him away to prison for his life? Or is it the other stuff, that holes that the defense was able to poke in this prosecution? And then it's three witnesses who said, two of whom who said, we saw a white Cadillac leave with Tupac, and moments later, the rap icon was dead. So we heard from another witness as well. Now, this was fascinating. This was a detective who, as a rookie, back 10 years ago after the shooting, 14 years after the shooting, had honed in on Tupac as his main, on Keffe D as his main suspect, and wanted to pursue an arrest warrant for murder. And he tried to track down this Cadillac to the best that he could, but he did not succeed, as we found out in a tremendous, dramatic testimony that was put on by the defense. It cut both ways, as some witnesses do. There was definitely some interest in the prosecution had in this witness, because this guy believed that Keffe D was responsible for killing Tupac. But the fact that he was unable to corroborate anything that Tupac said to him inside this law enforcement interview with all LAPD, with FBI, with different federal agents. So this is where we get a little more information on whether Keffe D may or may not have been in a Cadillac in letter D.
There was plenty of probable cause to arrest for murder.
For sure. Now, just for the jury's edification, probable cause is not beyond reasonable doubt. Fair?
I'd say that again. I'm sorry.
Probable cause is not beyond reasonable doubt, right?
No, that's what we do here.
That's correct. And in terms of the information that you had learned at the time that you met with Mr. Davis, did you verify any of that information?
Let's say it again. I'm sorry.
Did you verify any of the information in that recording in 2009 that Mr. Davis said?
I wasn't able to.
And once again, verification meaning corroboration, right?
That's correct.
In fact, I think on the recording you had told Mr. Davis a couple times, look, even though what you're telling me you might say is the truth, I still need to corroborate this information.
That's correct.
And that would have been your standard operating procedure with anyone telling you anything.
That's correct.
So for instance, as you're sitting here right now, do you have any...
I'm going to object to leading. It's his witness.
I'm sorry, I'm so used to
It's hard,
it.
I know.
Let me ask it this way.
You're gonna rephrase.
Yes, I'll rephrase. Did you make, was there any information that you ever received about whether or not Mr. Davis was in Las Vegas in September of 1996?
Well, objection leading.
He can say yes or no. I'll overrule.
Did I?
Yeah.
No.
And was there, did you ever have, when you reviewed the file in this case, were there any people calling in saying that they did it? They did the murder?
Sure.
I mean, can you give us a number or an amount?
There was a lot. There was quite a few. I mean, I had information that Bill Clinton had him killed. I mean, there was no, we did not follow up on that.
Clinton, president at the time, this fascinating witness, Detective Dan Long, has to be one of the more credible witnesses because he spoke, clearly that he thought that Keffe D was his guy, and he tried to have him arrested, and the district attorney at the time told him to stand down. Those were his own words. And the jury had more questions because of that, all of this fascinating testimony about the Cadillac, and then Michael Sanft getting this detective on the air to say, yeah, Keffe D said it all, and we had a lot in our records from detectives over the many, many years that this investigation continued, which put, possibly Keffe D at the center of this crime, with Orlando Anderson, his nephew, as the gunman. But the jury wanted to know more, and an inquisitive jury of 6 men and 10 women, 16 people total, 12 of whom will decide the fate of Duane Davis and 4 of whom will be alternates, had these questions for the same witness, questions we all had in letter E.
In a non-victim crime, you can work off charges. You can't work off a murder. You can't work off a sexual assault. You can't work. Those are victim crimes. If you have a victim, you can't work off those charges. But if you have something else that, like a lot of drugs, you could work off maybe the amount of years you're going to do by giving substantial case information on other cases. So that's what I believe that Mr. Davis and his attorney were trying to do, was to knock off a certain amount of time off of what he was going to spend in prison.
And or at least you believe, you'd agree with me, that Mr. Davis was a suspect in your homicide, not a witness.
Yes, sir.
And by the end of that interview, what is your intent?
My intent was to drive back to Las Vegas, type up a warrant for an arrest, clear it with the district attorney, and have Mr. Davis arrested for murder.
Well, Mr. Davis was arrested for murder, but not until many years later. And this detective wanted to get his man, and in fact ended up in what I'm sure was a cruel twist of fate, testifying for the defense. Not, I'm sure, what he wanted when he was investigating this shooting on behalf of Metro in California back many years ago. And he was able to find his way into an interview where Keffe D was speaking with law enforcement under a proffer. Essentially, the law enforcement coming to him and saying, "We got you, Duane, on these drug charges for which you could spend the rest of your life in prison. And if you want to work off that time," which is what the beginning of the soundbite was saying, "you're going to talk to us." And they made a deal with his lawyer for Keffe D to come present himself and answer questions. And he answered a lot of questions and, in fact, opened way up about the murder of the rap legend Tupac Shakur here in Las Vegas in 1996. And this police testimony was fascinating because he wanted to, Dan Long, the detective from Metro, wanted to arrest Duane Davis. And the prosecutor told him no. It wasn't until years later that they put a case together. The police searched Keffe D's home here in Henderson. They took those newspaper clippings and a Vibe magazine with Tupac's picture out from Duane Davis's house. That fact that it's just sitting there at his home with the books that were written and these many newspaper clippings from back in the 90s about the crime and the investigation and how it affected Gangland Compton, these were in his house, which someone could easily say is some sign that Duane Davis, the defendant, accused of orchestrating the murder of the rap legend, well, more than a passing interest. And it's hard to say that it's not. But it's also not proof that he put that together. We don't know the motive for why he would have done that. Maybe it's because he killed him. Maybe it's because he didn't. Maybe he was interested. Maybe he had a friend who thought, "Oh my God, I think Duane Davis would like to read these clips." It's impossible to say. But what we do know is that 2 police officers testified yesterday on the day of defense testimony when they called 3 witnesses, 2 of them saying that they saw a white Cadillac leave the gated estate of Suge Knight following Tupac Shakur, and moments later, he was dead. Now, what are the chances, the jury may ask, that there are 2 white Cadillacs traveling in the same orbit behind Tupac Shakur? Those officers have no reason to come up and say, "Oh, well, I don't think they could have a reason to say this, to introduce a second white Cadillac into testimony." It's mind-boggling. And this third witness, Dan Long, the detective, gave some additional fascinating testimony. In addition to all of the investigating he did into Keffe D, into the Tupac murder, into some of these associates, all of whom are now dead, including his nephew, the alleged gunman, Orlando Anderson, who died not too long after the rap legend Tupac Shakur at a shooting in a car wash in California. Well, we had heard that the file for the Tupac, the Metro's file, was a file of interest that people would maybe help themselves and take a little look, or maybe take a piece of paper out of that file, and that the file was a little bit too exposed. And one detective thought it better to, take the paper file and put it on floppy disks in order to make it so that people couldn't, be curious. And if they were, that they wouldn't be able to do anything about it. And that eventually, as technology enhanced, Metro moved from a hard drive to a larger hard drive, and magically, some of the reports in this case, some of the documents over these many years of investigation disappeared. And it's just another interesting place in this narrative where the plot thickens, and that is letter C.
Was there still an interest in the murder of Tupac at the time that you took over the case? Meaning, was there media attention? Maybe not to the level it was in the beginning, but was there still issues with regards to access to the file and that kind of thing?
Yes, there was.
And
Now I know where you're going.
Yeah, and what I mean by that initially is that even in Metro, was there any concerns on your part about unauthorized access to the file?
Not by me. I wasn't concerned, but my lieutenant had become concerned and wanted to sequester the file away from everybody else because there was a lot of people going in and looking. Very, very famous person.
And with regards to the going in and looking, can you describe to the jury what type of activity we're talking about here in terms of going in and looking?
I didn't do any investigation in this, but my lieutenant told me that people had been going in and being curious, looking at the file.
Did you at any point, was there any measures that was taken to preserve the safety and security of that file?
Yes.
What were those measures?
They locked down the file itself, which was the hard copy of the file. We used to, at that time, we were on a computer drive called the F drive, which turned out to be too small, and they later moved it to another drive because homicide just kept growing. So they changed the way I did my reports. I would hand them in, and they were secured. Those officers' reports don't exist anymore that I could find.
Okay, and why is that?
From what I was told was when we moved from the F drive to the H drive, those reports had to be scanned, and at some process they were lost.
Lost files, one of the many interesting turns and twists this narrative the prosecution and defense put on the stand took. Now here is Michael Sant's associate speaking about what she believes the judge should include in her jury instructions. The judge will read these jury instructions to the jury on Monday before closing arguments, explaining the areas of law. We are now about to see these legal arguments in Judge Carly Kearney's courtroom. Only the defense and prosecution, very few members of the public, but our 8 News Now investigator Vanessa Murphy inside the courtroom in what is supposed to be a short day of only legal arguments in front of the Judge Carly Kearney. So let's listen in. We'll be back during a break or at the end of this testimony on our stream of Nevada versus Duane Keffe D. Davis, the Tupac murder trial on 8 News Plus.
Raise the issues as they come up with the instructions. If there's something that doesn't get raised, ultimately by the end, then I'll circle back and ask about the defense proposed.
I would agree with that, except for I don't think you want a number, if you do wind up giving the voluntariness, I don't think you want to number them after the last instruction. So
you want to start with
maybe we should address
voluntariness?
whether or not we should be giving voluntariness, and then when we get to the area where you want to argue voluntariness.
All right. Let's go voluntariness of statement as our first issue. Let me pull up the instruction that you have proposed. Defense. And then state has presented an alternate.
An alternate, but also an argument that there is no voluntariness that gets submitted to the jury.
Okay. So is the instruction that you are proposing to give the one from Vasquez-Reyes versus State and Colorado versus Connolly, Ms. Benedict?
No, I am.
That's the one that the state is proposing.
My proposed is from Carlson versus State, 84 Nevada 534.
If you actually just want to approach with yours, at this point, I don't know. It doesn't look like I received your entire packet, so everything. So I can just go through it printed. Thank you. All right. So the instruction that the defense is proposing three different instructions, correct?
I have 3 different options. The first one is directly from Carlson versus State. The second 2 are from instructions that I used as a district attorney.
All right. So what's your preferred one that I start with?
I'm happy with all 3 of them.
Okay, so you'll take any of the first 3. So
Well,
either.
And definitely the second one on page 3 talks about the difference between an admission or a confession. So that one's different from the page 4 one, which talks about the totality of the circumstances and the voluntariness.
State, what's your objection regarding a voluntariness instruction being given at all?
In both the cases cited by the defense, and I recognize, both of them say where voluntariness of a statement is an issue, that you have to submit it to the jury. The mere fact that they filed a motion to suppress on voluntariness doesn't create an issue. They have presented, you have to, as Connolly says and Vasquez-Diaz says, you have to establish some improper police coercion, and they have not done that in this case. The audio of the statements do not reflect any improper police coercion. Both of those, neither one of those, have you found to be custodial, and so in both these cases, they're Mirandized statements of defendants who are in custody. There is a lot of law that, right, if there's evidence of self-defense, you got to give self-defense. If there's evidence of a voluntariness, you have to give a voluntariness, voluntary manslaughter. There is zero evidence before this jury that they could factually make any sort of determination as to the voluntariness of the defendant's statements. By its very definition, a proffer cannot be involuntary because it is a negotiated contract between two people. So the only statement this could apply to would be the 2009 statement. And when you listen to the 2009 statement, it's clear there's not a single improper coercive conduct by Detective Long. Now, had the defendant got on the stand and said, hey, they beat me with rubber hoses before I went in the room, or hey, the cops told me this, or the cops told me that, or the cops told me this. The evidence before this jury is he was caught with PCP and a gallon of PCP and a kilo of cocaine. They told me I could be prosecuted for that, or I could give a statement. I negotiated a contract with my lawyer, with the government, to go in and give them a statement. By its very definition, it cannot be involuntary. And so, if you instruct a jury on this, particularly the instructions they're requesting, it would be highly, highly confusing to the jury, and it's not an issue in the trial, because they've brought zero evidence of coercion, improper police coercion, into this case. And because of that, I would say they're not entitled to a voluntariness instruction.
In reviewing the instructions that are proffered, Ms. Pendick,
Can I approach to give you the two cases, Carlson and Morrison?
you may. My initial concern in reviewing what you have stated before I even get to the threshold matter of whether you've met, well, first I have to decide the threshold matter, but if we were to give an instruction, all instructions say that ultimately if a jury concludes that a confession or admission was not made voluntarily, then it's up to the jury to determine whether they should consider it. However, none of the three instructions give any insight to the jury as to how they would determine voluntariness. As a judge, when there's this motion to suppress brought up before me, in general, I have factors to consider. The jury would have none of those in the proposed instructions, and so it would be giving them a task that they have no way of accomplishing, essentially, is what is in front of me.
And what the defense is submitting in the Carlson case, they had an instruction that the Nevada Supreme Court ruled was sufficient in that case, and that is in the state's first proposed exhibit. And they actually gave the footnoted instruction of the fact that the court has admitted into evidence the alleged confession or admission of a defendant does not bind the jury to accept the court's conclusion, and the jury, before it may take a confession or admission into consideration, must for itself find whether or not it was voluntary confession or admission. If the jury concludes that a confession or admission was not made voluntarily, it is the duty of the jury to entirely disregard the same and not consider it for any purpose. That is directly from the Carlson case.
And they're saying voluntary carries a clear meaning without need for further definition or explanation.
That was going to be my very next argument, Your Honor. And they did say that it was error if the court did not give that instruction. And what they talked about was, and this is going to be something that's a theme running through all of our objections, there is a difference between admissibility and the question of fact that the jury now needs to decide. So here, Mr. Giacomo is absolutely correct that you have the initial determination of admissibility. You have ruled that it was voluntary. This will be an issue on appeal. This will be something that will be brought up by the defense should Mr. Davis get convicted. However, you also then are required by the Nevada Supreme Court to instruct the jury based upon their role now, which is determining whether or not there is evidence beyond a reasonable doubt. To me, that is how I read these Nevada Supreme Court cases, that you need to give these instructions. I do see the court and Mr. DiGiacomo's concerns. It is the defense position that we'd rather have all of the instructions given as opposed to just the state's. So I think it's better to instruct the jury than to not about all of the applicable rules. But I do think, and this will become even more important in the next argument about corpus delicti, I think that we do not need to instruct the jury on questions of admissibility. I do not want them to be confused about the proper standard that they need to decide, which is proof beyond a reasonable doubt. At this stage, it's a question of fact for the jury.
So let's work backwards then. Where in this record do we have evidence of improper police coercion, where we don't have, we have a statement that was given in the presence of police, or in the presence of his attorney that he brought there. We don't have any of the typical PASAMA factors present of, you know, someone who's very young, someone who's very hungry, someone who's very tired, someone who's very susceptible to police coercion because of their lack of familiarity with the criminal justice system. We have none of those factors present here. Additionally, we have a defendant.
Would disagree.
But hang on a minute, and we also have someone who has not testified to explain a circumstance outside of those. Outside of what is actually within the videos, and then ultimately no evidence that well, apparently it would be difficult to know what to apply to this situation, but what is the, I guess, improper police coercion here?
Well, the defense, we all should not be arguing this right now. It's a question of fact for the jury. I'm not going to restate the evidence that we already heard at the trial, because it's up to the jury to decide.
You need to make a prima facie case.
Exactly, but it is our position that those factors, whether they've been met or not, would be up to the jury to determine. Both sides are going to have arguments and closing arguments that are going to be very different. This is one of the biggest issues in this case, and I think it's important to continue on to allow these instructions to be given as decided by the Supreme Court. I think it would be error not to give the instructions, and I think that there is some evidence of psychological pressure. That is going to be something that the defense may argue in this case based on the testimony at trial, but I don't think it's appropriate for us because it's a question of fact for the jury.
But we need to get at least that there's something in the record to show, you know, like if we're talking about a voluntary manslaughter, you have to have at least that scintilla of evidence to get over that very small molehill. What evidence is there to give these voluntariness instructions at all to get that first hurdle that Mr. DiGiacomo is, I guess, complaining about?
And I know that this court disagreed with the defense when it filed its motion to suppress the statements, but the defense detailed at length what the promises were. There were explicit promises made to the defendant in the 2008 proffer. There were implicit promises not to use it against him in the second 2009 interview, and those promises, while contested by the state and contested by the court, there was evidence of promises made to the defendant. There was evidence about confidentiality that they agreed to keep. There was evidence about when that confidentiality was broken, who broke it first. These are all issues that are going to come up during closing arguments, and I'm sure they're going to be issues that are going to be deliberated by this jury in making a decision.
But none of that goes to voluntariness. So, somebody violating something 5 years or 3 years afterwards doesn't change the voluntary nature of the statement. The person or the entities that contracted have never violated the agreement that was contracted. The contract was between Mr. Higgins and the U.S. government. The U.S. government never violated the contract. The suggestion that as a matter of law, you can never have an involuntary proffer. There would have to be some additional information that is elicited. The fact that they don't like what Mr. Kading did does not somehow change the nature of what happened 3 years before. And so the psychological pressures that they're talking about are exactly what Colorado v. Connolly say are not appropriate for purposes of the Sixth Amendment involuntariness. That is clearly not a situation where they're allowed to argue to a jury that because him and his family were wrapped up in a drug deal, that he somehow has the right to claim that his statements are involuntary. The Sixth Amendment is there to protect against improper police conduct. It is not there for this purpose. So when they use the term voluntary, he didn't have a choice. Well, he did have a choice. He could go to prison for the rest of his life on drugs. But he chose to make a statement to the police. And so there is no evidence of anything improper police conduct that has occurred here.
May I add something, Your Honor?
You may.
I wanted to clarify that the burden of proof is on the state to prove by a preponderance of the evidence that the confessions were voluntary. That is a burden of proof at the time of trial, not at the time of the motions. So in this case, they do have that burden to prove that beyond a preponderance of the evidence. So I think that's also relevant, and I think it's important in this case that we give this question to the jury based on the Supreme Court law that's in place. But as Your Honor well knows from all of the briefing in this case, there is very little law specifically on point to this issue. This is a unique issue. This is something that could create new law in the state of Nevada because there's very little law in Nevada that even remotely talks about the situation that we have in this case. And I think that it's very important to protect the record that the instructions be given. And I'll submit it to Your Honor.
Okay. I think it's safest to give some sort of voluntariness instruction to this jury. Given the precedent in the Nevada Supreme Court, given the Carlson versus State case, I definitely agree with a lot of the state's arguments, and that's why I ruled the way that I did initially. However, it's clear that this has been an issue that has been raised by defense. It's something that they disagree with my ruling with pretty strenuously. And in the record, there is, that statement by Detective Kading in that 2008 interview that this will never be used or this will never be heard, which was the basis for that voluntariness. I still think that wasn't the correct framework, but I think giving it ultimately to the jury is maybe a way to hedge our bets. So, that being said,
And I'd ask you
let's talk about the various instructions and how we're going to do this.
I would ask the court, and I will tell the court that, I cannot believe I'm actually going to say this, but I pulled those instructions on voluntariness from the Nevada pattern jury instructions. The only thing I did was conform slightly to this case and added the Colorado v. Connolly portion that says self-interest or an expectation of receiving a benefit does not make a statement involuntary. That isn't actually in the pattern instructions, but clearly it's the law, and that's why I sent you Vasquez-Reyes, because Nevada has adopted Colorado v. Connolly. Mm-hmm. And so the instructions I gave you on voluntariness, and I'm trying to pull them up here because I didn't have them up on my computer initially here.
And so these are, your instruction is the pattern?
is the pattern with the exception of the last line on the first page,
Okay.
I believe.
And so, Ms. Pondick, the instructions that you've given me, obviously the one on page 2 involves Carlson and Lorson.
Yes.
Those are Nevada Supreme Court cases. The other 2 sites are simply to the stock CCDA brief bank instruction. Do you know where those necessarily come from, and if they were not incorporated into, ultimately, kind of the pattern, the idea was to incorporate those stocks into the patterns?
Those have been instructions that have historically been used by the district attorney's office that have been upheld by the Supreme Court. So those have not been challenged. Those haven't been, there have been no problems associated with those instructions. That was initially what I had asked the state to include that precipitated all of this.
Okay.
So I wanted to make sure that the court had those instructions. I agree with the state that their instructions are a correct statement of part of the law that applies. I'm not saying it's complete in terms of all the issues in this case, but as to the PASAMA factors, those are the factors, and I do agree that they're correct statements of the law. So we do not object to the admission of all the instructions, both the state's proposed as well as the defense proposed.
Well, the second 2 DA brief bank, I'll be honest with you, and then, you know, she was at appellate for a long time. Those are no longer in our stock instructions. These pattern instructions of what we've put into our stock instructions, because those are clearly, as the court noted, not adequate to explain to the jury voluntariness in a legal sense what that is. And so if you're going to give the instructions, I would urge you to give the Nevada pattern instructions with the Connolly addition to them. But not, well, I mean, I think it's superfluous to even have the what is it, the Carlson-Larson one, because these fully explain, these 2 instructions fully explain, hey, there's a confession and an admission, here's what the difference between the 2 are, here are the factors to consider in determining voluntariness, there needs to be improper police coercion involved in them.
I don't believe those 2 are sufficient. And I think that under Carlson, them saying that the term voluntary contains a clear meaning without need for further definition or explanation, that's also a clear mandate by the Supreme Court. But I would ask at a minimum.
Mandate from 1968.
Right. But there's been nothing.
In which the defense was actually asking to give the factors to the jury, and the court said it was sufficient in 1968. But this is a very specific voluntary issue, right?
Okay. Turning back to Ms. Pondick, when I look at the instruction the state is offering, it does seem to incorporate what you've included for 3. It talks about what an admission is, what a confession is, and what the definitions are. It seems to be very similar language, and I think it was probably what was used to make the stock pattern, the stock instructions that the Supreme Court is encouraging us to use.
Yes.
And so it seems to be the predecessor to that. Would you agree with that?
Yes, it is fine to use both of those instructions.
Well, I'm just saying, I don't know that we need instruction 3 if that one is being given.
That's fine, Your Honor.
Okay?
I just want to make a complete record.
No, I understand. I'm just, if you agree with me that it's already incorporated in the instruction, I'm not going to give duplicates. Okay. So
exactly.
3 doesn't seem to make sense. Page 3 doesn't seem to make sense. Page 4, let me compare that. I think page 4 does include additional factors, which include that the state has the burden of proving voluntariness by preponderance, but then it goes into the voluntariness being a question of fact to be determined by the and what you're to do if it is determined to be involuntary.
And I would ask that that instruction be given.
So I think 4 is incorporating your instruction 2. It has all the same features. So my thought is to give the state's instruction as well as page 4. And I'll let Mr. DiGiacomo be heard on that, just because it will avoid duplication of the exact same issues that could confuse the jury. Additionally, it includes an explanation to the jury of what to do to determine if it's when you determine it's voluntary or involuntary and who has the burden.
Okay, so you're going to give both of the states and then you're going to add 4?
Oh, the state has a second?
Yeah, the second
I
one.
haven't gotten to the second.
Yeah, the second one actually has all the factors listed out, and it does cover everything that's in her number 4.
Okay. Let me look at that one. I apologize.
Which one are you on? Page 2?
Page 2 of ours, the PASMA factors.
The state, and it includes that the state has the burden of proving, which I indicated earlier was a very important part of instruction 4. I think ultimately in comparing page 2, it does encompass all of the ideas of page 4.
So instruction number 2 will not be given on page 2.
Right. I think what she's saying is she's going to take R2, it encompasses all 3 of yours. Is that what you're saying?
No, she's going to give on page 4.
Well, I didn't realize there was a page 2 to the state. What does the state's proposed either omit? I see that it adds the PASMA factors, and you guys don't want the PASMA factors given. Is that sort of the difference there?
I already said it was fine to give all 5 instructions, so I'm not saying that their proposed instructions are an inaccurate statement of the law.
Got it. Understood. So at this point, I'm going to give voluntariness instructions over the state's objection. However, I'm going to use the 2 that the state has proposed because they are pattern instructions, which we're encouraged to use. Additionally, in reviewing them and comparing them to the ones that were sent over by the state or by the defense, they do include all of the factors, as well as the fact that the state has the burden of proving the voluntariness by preponderance of the evidence. So I think they encompass everything that is necessary. They encompass the defenses, and to avoid confusion, I'm not going to give all 5. I'm just going to give the 2 that include the same ideas.
What about the one on page 4? You had said earlier you were going to give that one.
And I think that was before I knew that the state had given me even a second page.
Oh, okay.
So I was just looking at page
Okay.
1. I apologize. So now that I've got that. All right. So the voluntariness instructions will be given as proposed by the state, but to be clear, the state does not want voluntariness instructions. The other issue that we needed to address was corpus delicti. The defense is proposing on page 5.
And to be clear, Your Honor, the defense objects to the corpus delicti instruction proposed by the state. The only reason that we provided an alternative proposed instruction is because they included it in their packet. The defense objects to any corpus delicti instruction being given to this jury at all for these reasons. While the first attorney in this case had potentially raised a corpus delicti issue in his motion to dismiss, this defense team has not raised corpus delicti either in a motion or in front of this jury. That issue has not come up. It is a question of admissibility, not a question as to weight, and the defense objects to this instruction being given because we believe that it is confusing and misleading to the jury because their duty is beyond a reasonable doubt, and their duty is as to weight, and it's confusing to even have this instruction. However, if the court disagrees with the defense position and will give an instruction, the case provided by the state, Sefton, that's actually from 1956, and the proper standard is the Doyle case. In the Doyle case, they provided, this is the exact instruction that comes out of Doyle, which is Doyle versus State, 112 Nevada 879 from 1996, Nevada Supreme Court, and that instruction is a more accurate statement of the law.
Your Honor, may I be heard?
Which one is your corpus instruction?
That is on page 5.
No, sorry, states. I'm on yours.
Okay.
Somebody, it's near the end.
Give me the first couple words once you find it so I can.
Where independent evidence.
Where independent evidence. Okay, then I can control that then.
It's about 42 of 53. Although I may have I just added in the voluntary instructions, so maybe not.
So the instruction the state is proffering reads, where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. I don't know that that's necessarily a corpus issue.
It is, Your Honor. So this is what, and I'm going to disagree with Ms. Panduck with regards to the defendant's the never taking the position that about the corpus delicti issue. What Mr. Saft told the jury in his opening statement is, you have to corroborate what the defendant says. That is not the law. So the question is, when we talk about what's clarity to the jury, what is the law? The law is we have to prove when a person gives a confession, absent their confession, we have to prove, one, that a person is killed, two, by the criminal agency of another. But what Sefton says, and what even Ms. Panduck's case says, and I'll get to why that's not applicable here, but what even Ms. Panduck's case says is that once you've established there's a crime occurred, you don't have to corroborate any other aspect of a defendant's statement. Now, of course, they can give it to whatever weight they want. But
Isn't that the inverse, though, of what a corpus argument would be? Is that there is only a statement and nothing to back it up. Yeah. You're kind of inverting it.
No, what Sefton, this came up specifically in Sefton. In Sefton, specifically what happened was there was a dead body, the person confessed to the crime, and what the defendant argued is, well, you never independently corroborated my other statements connecting me to the crime, therefore it's a corpus issue. And what the Nevada Supreme Court held is that there's not a third prong to corroboration. There's one, death, two, by criminal agency, three, what the defense had proposed, and what Mr. Saft has proposed to this jury specifically is that the third thing you have to do is corroborate that a defendant's statements connecting himself to that crime are true. And I don't think there's any credible argument to say that that's not what Mr. Saft said. I mean, it's a direct quote from his opening statement. But that's not the state of the law. And what Mr. Saft, when Mr. Saft makes a argument that is an inaccurate aspect of the law, increasing our burden, we are entitled to an accurate statement of the law. And what an accurate statement of the law is that we do not have to corroborate anything beyond the corpus delicti. That is the corpus delicti rule, is that we don't have to corroborate anything beyond that. And so the question before this court is Mr. Saft, because he's certainly going to say it during his closing argument, and he said in the opening statement, is Mr. Saft allowed to give a false impression about the law to the jury? And the question of that should absolutely be no. Because in the absence of anything, with the absence of an instruction telling them that that the corpus delicti rule is that we don't have to, and even if you don't want to call it the corpus delicti rule, the rule is, regarding confessions, is that we do not have to corroborate anything beyond person being killed and the criminal agency. And so Ms. Panduck, again, in Doyle v. State, the thing that she pulls is from a kidnapping case, or from a kidnapping charge. But in another case that Ms. Panduck cites, West v. State, gives a very similar understanding of
You actually cite West v. State, too.
Yes, well, she cited it, we cited it, we both cited it.
Yeah.
And the one thing that we can agree is the two parts of corpus delicti, the only thing that we have to independently establish is the death and by criminal agency. That's the only thing we have to establish. We don't have to corroborate anything else. And so the only question is the jury going to have to be, is the jury going to be misled about whether we have to corroborate or not? And what the instructions are there to do is to have them not misled as to what our burden is.
May the defense respond.
1 second. I'm not quite through with understanding the state's argument. Sefton states that you need, for a homicide, you need proof of corpus delicti, which we've always had in this case, right? No one ever
Never challenged that. Well, not during the trial.
There have been challenges to which, in the media as to whether Mr. Shakur is alive or dead, but in general, we've always had the fact that Mr. Shakur died that day, and the body of the crime has always existed. And so corpus delicti wasn't really the issue here. It was the defendant's corroborating confession. Is that enough? And so...
Okay, so we can...
So I think that's...
So if you want to get rid of the first sentence where independent evidence established that the victim's death was caused by criminal agency another, that's fine. But a defendant's own statements admitting the crime need not be further corroborated as an accurate statement of law. And if I may read from Sefton v. State, it does say, a conviction based on confession will stand, although it is uncorroborated otherwise by proof of corpus delicti. So what Sefton specifically says is, we do not need to corroborate a defendant's statement. What Mr. Sanft told the jury is we need to corroborate a defendant's statement. So the question before this court is simply whether the jury gets the accurate state of the law or they do not.
You may respond.
Thank you.
Ms. Conduct.
What the state argues is actually incorrect. The issue is regarding admissibility. So this instruction is only relevant for admissibility. If there was no corpus delicti, then none of the defendant's confessions could even be admitted at all. You would have been precluded from admitting them to even let the jury hear about them. What the defense's concern is now is that this is improperly impeding upon their duty to find guilt beyond a reasonable doubt. This is infringing upon that standard. There is absolutely no law that talks about the fact that you do not have to corroborate a defendant's confession in terms of a jury verdict with beyond a reasonable doubt as a standard. And I would like to use the example, there is one situation, that is the Gaxiola case, and the Gaxiola case, I believe, oh, here it is, I have the site. 121 Nevada 638 from 2005. The testimony of a victim of sexual assault does not need to be corroborated, and that is entirely different than the situation in this case. The confessions were admitted into evidence. That was correct. They absolutely can be admitted into evidence, but this instruction improperly instructs the jury that there's arguments by the state, arguments by the defense, that they get to consider. They get to consider all of the evidence, and we cannot interfere with the burden of proof. So the state is wrong.
So, Your Honor, if I may be heard, like Sefton is not about admissibility. Sefton doesn't say this is about admissibility. It is about the threshold of proof, which is here. Now, if the court wants to add, it's still up to the jury to determine what weight to give to a statement. That's fine. But in terms of like the inaccurate statement of law being offered
Where
to the jury,
in Sefton does it say a defendant's own statements admitting the crime need not be further corroborated by evidence connecting the defendant to that crime?
okay, it's if you do a Control F cert, F5 if you want it, if you're there.
Sure.
It says use conviction based on a confession will stand, although it is uncorroborated otherwise than by proof of the corpus delicti.
It doesn't cite to any other cases.
Actually, it does. In footnote 41, it goes on to say, it says, to this text, many authorities in support of this rule, and where corroborated evidence has been adduced, the rule is further stated. The corroborating evidence need not be such as to connect the accused with the crime. And then it goes on to say, hundreds of cases supports this rule and are cited in this note.
I believe Doyle supersedes that.
All right, let's look at Doyle.
And again, Doyle is
a kidnapping case.
Doyle is, they're talking about specifically a kidnapping case. Or a kidnapping charge. It's a murder case, but a kidnapping charge is where the corpus comes in.
I don't think that matters.
Instructing a Gaxiola, but not instructing this case.
The West case that you guys both agree on, let's talk about that maybe.
Okay, well,
so that is clearly, that's a no body homicide, correct? Brookie West, right? That's
Yes,
what
there
you're
was
citing?
no body in that
Okay.
case.
So obviously a very different situation.
yeah, that's just the two precedent factors that the state has to independently prove, which is the fact of death and the death occurred by the agency of another.
And I don't want to jump in, but she mentioned Gaxiola. Why would we be entitled to instruct a jury that a victim's sex assault cannot be corroborated, but we can't instruct that in a defendant's statement? Gaxiola supports the argument.
And this isn't an attempt to change the burden. If the court wants to add to this that, you know, the state still needs to prove the case beyond a reasonable doubt, or it's up to the jury to give what weight it wants to give to the statements, that's fine too. But it is axiomatic that we do not have to corroborate a confession. And the law supports that position. And Mr. Samt has told the jury different, which is not true.
Or need the proof of corpus. So really the argument here boils down to whether the defendant's statements need to be corroborated by any evidence, or in the case of the misconduct is stating it needs to be slight or prima facie for the kidnapping.
Well, that is regarding whether the crime occurred. That's not even about whether or not his the statement. I mean that what.
Right. Okay. Because when in the kidnapping context, there's a situation where that crime could have not occurred.
Right.
There could have been no kidnapping whatsoever. It could have been a complete fallacy, a complete made-up situation. Whereas when we're talking about a homicide, there is proof of corpus automatic within the body existing.
Correct.
Okay.
Doyle is just not used in kidnapping cases. That's the standard that's been used since it came out. Everyone cites to Doyle. Doyle is the standard for the corpus delicti rule.
Not according to West, which says the corpus delicti rule in Nevada is well established. To prove that a murder has been committed, the state must demonstrate the fact of death and the death occurred a criminal agency of another. So that's what we got to establish. And then independently. And then the only question is, do we have to corroborate anything else or not? And the law is clear. We don't have to corroborate anything else. Now, of course, Ms. Pandick does have a fair point. They're not required to accept it. But we're also not required to corroborate it. And that's the impression that the jury was given by Mr. Saft when he said, you are required to corroborate it. We know that's not the law.
A defendant's statements essentially, if believed, kind of borrowing that phrase from Gaxiola.
Okay, yes. If believed, that is fine. I think that's fair. They don't have to believe it. I'm not trying to communicate that. I'm saying they don't have to believe it, but they don't have to corroborate it.
The defense still believes that also in West, it says corpus delicti must be established before evidence of a confession or admission may be considered to prove that the accused was the criminal agency that caused the victim's death.
Yes.
So the defense maintains this is a question of admissibility, not a question of fact for the jury. It doesn't apply and should not be given.
You just stated that in order to get into the statement, you have to show that a crime has been committed. And the state did that because we have a body. That's literally the corpus. So a corpus is beyond approved, right?
Correct.
So Brookie West is totally different because Brookie West, there's no body. And so how do we know that it's a crime? Those are all the issues. Here we have a body. We've always had a body.
I know, but I don't think the instruction should be given because it was not an issue in this trial.
Corroboration.
You admitted the confessions. This would be an issue to keep the confessions out of the jury's hearing. But here, they got to hear all the confessions. So now we're infringing upon the right of counsel to argue their case in front of the jury and the right of the jury to make the decision, the duty of the jury to make their decision beyond a reasonable doubt. This instruction should not be given at all.
All right, so
I'm sorry.
you might want to just listen for a second, Mr. Paul. Okay, so the state's instruction, I believe, is in reading through and reconciling it with Sefton versus State, as well as the reiteration in the Brookie West case, is a correct statement of the law. However, I think the arguments of defense and everyone has been that these statements are not to be believed. And so I think the if believed language borrowed from Gaxiola adds that component in. So what I'm going to do on this instruction is say where independent evidence establishes the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime.
Your Honor, so you're going off of the states?
Correct.
Can you do it a little bit slower, please?
Absolutely. I'm going to send you guys a copy of everything, but where independent evidence establishes that the victim's death was caused by the criminal agency of another, and just paraphrasing, that is directly from West, a defendant's own statements, if believed, admitting the crime, need not be further corroborated by evidence connecting the defendant to that crime.
Are you going to add any of this defense proposed exhibit, the defense proposed instruction?
So, the defense. Well, the defense proposed instruction says there needs to be slight corroborating evidence independent of any confession or admission, but that ultimately goes to the crime, to whether corpus is established. So the first paragraph the first line is literally saying where corpus is established, but explaining what corpus is. So I don't think that there's any way, given the court's ruling, to include that a slight or prima facie showing permitting the reasonable inference that a crime was committed is sufficient, because that would be impeding essentially on the corpus determination, which we've all agreed in this case is established. There need not be. And additionally, the final line of what this defense has proposed does say there need not be independent support for each fact contained in the confession or admissions in order for the crime to be proven independently of defendant's confession or admissions. Is that something that you're seeking to have added, Ms. Panduct?
I moved to have the entire
okay.
instruction, and I would ask that any part of it still be given, because I believe it is more informative and less confusing and misleading than the instruction that the state is proposing.
Okay. Any objection to the final line being added?
Yeah, I think it actually confuses the instruction as currently given. There need not be independent support for each fact contained in the confession or admissions in order for the crime to be proven independently of defendant's confessions or admission. To me, is less clear than defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. I think our language is far clearer for the jury, and I think this is more duplicative than anything else.
I also believe that there should be a reasonable doubt admonition then as well placed in here. I believe this is still confusing to the jury, and the defense should be able to do the arguments as they intended.
What's the proposal to add a reasonable doubt instruction into this instruction? Or is that something that you
I would ask
could be fixed by putting it close to the reasonable? Well, what are you asking?
No, I would ask that in this instruction, right after here, that it is up to the jury to determine the weight to be given to the confessions or admissions, and they must determine beyond a reasonable doubt.
I don't have a problem.
But definitely weight.
Yes,
It is up to the jury to determine the weight to be given any statement or any confession or admission.
I think that's a fair statement of the law, and so I don't have any objection to that.
All right, so that instruction will read as follows. Where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. It is up to the jury to determine the weight to be given to any confession or admission.
That's not the statement.
Okay. Obviously over objection, but incorporating some of the defenses, that is how that, suggestions, that is how that will be given. And then the final issue we have before we dive into just going through the instructions one by one would be the argument regarding self-defense. My initial reaction when you said this was self-defense is ultimately a defense. And so all of the instructions in Runyon go to the amount, or whether they're given, goes to the amount of evidence that a defendant presents, and that a defendant argues. And I've never seen it given over the objection of the defendant.
Well, while I appreciate that, and I know Mr. Sampt has made a number of arguments to this jury, there is evidence of self-defense present, and the state is required to rebut that evidence beyond a reasonable doubt. Part of that evidence of self-defense involves him being the initial aggressor. So the jury has to know that while he may have asserted self-defense, let's say they only believe the book version, right? Or they reject everything else and only believe the book version. The book version is it was committed in self-defense, right? It's sort of like the mere presence instruction that's in here. The 2009 statement is more, I'm merely present at this particular event. Both the 2017 and the 2019 book is like Tupac shooting at us, so someone from the back seat started busting. Okay, well, Tupac would have been allowed to shoot at you. I know that there isn't a lot of evidence to support that, but the jury needs to be instructed on what the elements of self-defense are, because one of defendant's defenses, not Mr. Sam's, but defendant himself, in his own statements, his defense is self-defense. And so we're entitled to have a proper instruction of that isn't self-defense. Even if you believe what he says only in the book, that is not self-defense.
But in order for you to tie Mr. Davis into this event whatsoever, there has to be an overarching plan already at the time that the self-defense came in.
I agree. That's why legally, right? Legally, he's wrong, right? He doesn't know the law of self-defense, but a lot of defendants give confessions and statements and go, hey, it was in self-defense when they ran up on somebody with a gun and that guy pulled the gun out and shot at them and hit the woman behind them, right? I mean, that case we have right now. That defendant says, oh, I committed the crime in self-defense. Well, as a matter of law, you ran up with a gun on somebody, you don't get to claim self-defense. So the jury needs to be instructed on what the law of self-defense is, because there is some evidence of self-defense in the case. Whether the defense is going with that defense or not, whether Mr. Sampt argues it was in self-defense or not, isn't relevant. The law is, if there's evidence of self-defense present, the state must disprove it beyond a reasonable doubt. And since the defendant has asserted in at least two statements that the car was acting in self-defense, the jury's entitled to know what the law of self-defense is.
Remind me, does he actually say
He says the word self-defense.
self-defense, or does he say that, we thought he was going to get to popping or something like that?
No, at one point he says...
I'm confusing it with a different statement.
At one point he says, and I can't remember if it's in 2017, I think it's in the 2017 audio recordings, where he tells Mr. Diaz, yeah, it was in self-defense. He actually uses the word. I can word search the various statements, but when I heard that, that's what caused me to go, wait a second, we need to put an instruction in here because...
Okay, so I guess I see where you're coming from now. Defense, what's your position regarding this?
First of all, I would note that if the state brings these instructions in, they're adding to their burden of proof at trial, because they have then the burden of proving that the defendant did not act in self-defense. So I don't know why the state would want to add to their burden if the defense is not even requesting.
Leave that on them. You don't have to worry about that anymore.
That I don't understand.
Okay.
We're not asking for those instructions because we are not going to be arguing self-defense. We believe it would be confusing to the jury. It certainly is an accurate statement of the law under Runyon, but also under Runyon, it's up to the defense to ask for those instructions. I don't know of there being any case where the state can ask for them when the defense has not, but in the end, the defense will submit that to your honor.
Okay. Final word, state?
Yeah, it's in 2017. where Mr. Diaz is, so you're saying it's in self-defense is what really happened, and Davis says, yeah.
So Mr. Diaz says it.
Well, he uses the word self-defense, but I mean, the description of what Mr. Davis is saying is, hey man, Tupac pulled out a gun and started shooting at us, and so we had to shoot back. And so Diaz is saying, so you're now saying it's in self-defense, and the defendant says, yeah.
I mean, Ms. Pandak brought up a good point. I don't know why you'd want to take on a burden of disproving something that they're not even raising, but
Well, that's on me though, right?
yeah. All right, I'll give you the running instructions. So we've gone through voluntariness of statement. That was granted, we're going to give instructions on that. Over state's objection, we've gone through corpus delicti. That was given over defense objection, and then self-defense is sort of, you're asking to take this on, and we're not sure why, but you want it, so we're going to give it to you. All right.
Also, for the record, I don't know if I made this record earlier, but there were wordings in the state's proposed instruction that I suggested making some additions, and the state granted that, and they made all the additions that I requested to other instructions, so I don't think we need to make a record as to those specific.
Except for she doesn't have those in front of her. I have been taking down notes of everything you said. I now have a clean copy with our instructions in order as it relates to the voluntariness. How about I save these, send them to the court, and we use those
Oh,
to
you
do
don't do
the
that in every other case. How come I have to do it in every other case? Anyway, okay, just kidding. All right, so at this point, I'm gonna have you email all the parties with the notes that you've taken. We'll review them, and then we'll go through one by one, making sure there are no further objections. While you're doing that, any way you can make page 3?
I mean, maybe,
Yes, to
maybe
not go
Ann
more.
can get page 3 to get that word off. I couldn't figure out how to
Question
get.
on that, determine whether or not the defendant is guilty of one or more of the offenses charged.
Guilty, I guess,
Of the offense charged, because there's
of
only
the
one
event,
charge.
yeah, well, that'll solve it.
Okay,
Or just don't make it an extra.
Of the offense charged.
or make it small.
Guilty of one or more of the,
Okay, if you do guilty of the offense charged, it actually fixes the issue.
it does.
Okay, so.
Let me
that was
save
just us
this as
being
the final.
Style wonks. All right. Send it over.
That's charged, okay.
Yeah, before I make sure I did put those Passimo ones in here. And there's self-defense. Come on.
So the one that you sent me at 9:13 a.m.
Didn't have the self-defense ones in them, or not the. It didn't have the Passimo ones in it in place.
Okay.
So that's why I added those. Proffer agreement, statement, one statement made during police interview. Okay, yeah, they're in here. Okay, this is ready to go. I'm emailing it now.
Thank you. Do you have the Bolden instruction in there somewhere?
There is
On conspiracy?
multiple versions of Bolden in there. Do you want to send it? Do you want me to send it to Ann too?
No, I'm gonna print it out myself. And you're getting rid of the sites on the Sefton and West case, obviously.
Oh, did you have sites on there? Hold on a second before I do this then. Oops,
Is there a playback in here too somewhere?
there is.
Okay.
Okay, I think it's good now. Let's see. Instructions. Insert. Okay. I think these are all right. People check. Mike, I didn't send it to you. I sent it to Megan. I sent it to Colleen and Megan.
How dare you?
Because I know you don't even know how to open your email.
Well, I have it open, just waiting for it right now.
Oh, well, you want me to forward it to you right now?
No, I don't want to read it.
That whole law thing gets in the way of what we do.
Words.
So then just do a final run through. I'll let you read through and make sure that that's what you've agreed to, or what you've all either, made a record on and I've ultimately made a determination of misconduct, okay? Okay. And then I'll number it if that accurately reflects what we have done here. Okay, so it is now my duty as judge. Any objection?
Judge, they don't have a copy.
Oh.
So, I emailed it to them, but they don't have a computer.
No.
Oh,
So can we print a couple of copies? We'll just do it manually.
That would be great.
sorry, trees. Okay, did you get an email to you?
It's
Okay, I'm
totally
gonna forward
Colleen.
it.
You're so non-green.
It is me. I'm very old school.
I'm just gonna go print and back. It's fine. I'll be back.
Thank you.
You're welcome.
I'll get you a new copy of our brief. This is only the second trial where the voluntariness of a defendant's confession has ever been submitted to a jury.
Really?
125 trials in, only one other time have I had somebody ask for it.
I've always asked.
And in
I've
that
always
case,
included it.
the defendant did get on the stand and said they beat me with rubber hoses.
I've always included it.
Live pictures inside the 12th floor courtroom at the Regional Justice Center in downtown Las Vegas, the epicenter of the legal world as the world watches the Tupac murder trial. Duane, Keffe D. Davis on trial for orchestrating the murder of the rap icon here in the streets of Las Vegas in 1996. Defense attorneys and prosecutors arguing the finishing touches on the jury instructions that Judge Carly Kearney will read to jurors on Monday before closing arguments. There you see Michael Sampton, his associate, and in the foreground, Mark DiGiacomo, the prosecutor, walking to the prosecution table. You also see in the center of our screen 8 News Now investigator Vanessa Murphy, who has been in the courtroom throughout the entire trial, perched in her second row aisle seat, providing excellent commentary or live reports for us every day on 8 News Now at 4, 5, and 6 with Denise Valdez or Brian Loftus on our wrap-up show that we have every night here at 7 p.m. Las Vegas time. On 8 News Plus, you're looking at the empty chair of Judge Carly Kearney. The bench abandoned momentarily while she reviews some of the prosecution and defense arguments on what exactly she should advise the jury with regard to the law and how they consider the facts in this case. This will give us an opportunity to take a short break while we get ready to recap for you the morning in court on day 10 of Nevada versus Duane Davis, our wall-to-wall coverage of the Tupac murder trial on 8 News Plus. Stay with us. 8 News Plus live wall-to-wall coverage of the Tupac murder trial. I'm Kyle Payne as we are in day 10 of Nevada versus Duane Keffe D. Davis, accused of orchestrating the murder of the rap legend Tupac Shakur here in the streets of Las Vegas in 1996, almost 30 years ago to the day. Here's Judge Carly Kearney back on the bench talking with lawyers about their legal arguments and jury instructions that she will read to the jury on Monday before closing arguments. Let's listen in.
Now my duty as judge. Any objection?
No.
No.
That'll be 1. If in these instructions any rule, direction, or idea is repeated,
No objection.
that will be given as 2. An indictment is but a formal method of accusing.
No objection.
No objection.
That will be given as 3. A conspiracy is an agreement.
No objection.
No objection.
That will be given as 4. It is not necessary in proving a conspiracy.
No objection.
That will be given as 5. Each member of a criminal conspiracy is liable.
No objection.
That will be given as 6. If one member of a conspiracy withdraws,
No objection.
that will be 7. Evidence that a person is in the company,
No objection.
that will be given as 8. When 2 or more persons are accused of committing a crime together,
No objection.
that will be given as 9. Murder in the first degree,
No objection.
I think that should be is a specific offense crime.
Yes.
That's correct. It should be.
Okay.
Is a
Specific offense crime, not, yeah. No S on crimes.
yes.
Murder in the second degree may be a specific, a general intent crime. Okay.
And that is number,
Actually, murder in the first degree is a, shouldn't it be specific intent crime?
Yes.
yeah, specific intent, not specific offense.
Yes.
Specific intent crime.
Yes.
And you're gonna clean these all up for the next time I use them.
All right, the next one, in this case, the defendant is
Is
accused.
that 10, Judge?
That was
That
10.
is 10.
Okay.
In this case, the defendant is accused in an indictment.
No objection.
That will be 11. Murder is the unlawful killing of a human being.
No objection.
That will be 12. Malice aforethought means the intentional doing of a wrongful act.
No objection.
No objection.
What number would that be?
13.
13? Okay. Express malice is that deliberate intention.
No objection.
No objection.
14. Murder of the first degree is murder.
No objection.
No objection.
That'll be 15. Now we're into the Byford series. The law does not undertake to measure in units of time.
No objection.
No objection.
That'll be 16. Although your verdict must be unanimous as to the charge.
No objection.
17. The next one is you are instructed if you find the state has established.
No objection.
No objection.
That will be 18. All murder which is not murder of the first degree is murder of the second degree.
No objection.
No objection. Oh, I'm sorry, no objection.
Is that 19?
That was 18.
18?
18.
Thank you.
No, that last one was 18.
Yep.
So this
Okay.
is
Oh, so no,
19.
yeah, murder, which is not first.
Is
That's-
second is 18.
No.
It's 19, I'm sorry.
Is 19.
All murder is 19. We on the
Great.
same page?
The killing of another person in self-defense.
So we're getting these?
Yes.
Okay. I will rely on my previous objection
Of
for
course.
the record.
But you agree that's what we've agreed to essentially.
Yes.
All right, so that'll be 20.
These are correct statements.
These are all Runyon. A bare fear of death, another Runyon instruction will be given as 21.
Yes.
An honest but unreasonable belief in the necessity for self-defense, that will be given as 22. The right to self-defense is not available to an original aggressor, will be given as 23. Actual danger is not necessary to justify killing in self-defense, will be given as 24. The killing is justified even if developed afterwards, the person killing was mistaken, will be 25. If evidence of self-defense is present, state must prove beyond reasonable doubt defendant did not act in self-defense, will be given as 26. If a person kills another in self-defense, it must appear, will be given as 27. And then we're out of the Runyon series.
Okay.
Okay. Then we're into the deadly weapon enhancement. You are instructed if you find defendant guilty of first or second degree murder, you must also determine whether a deadly weapon was used.
No objection.
No objection. 28.
That'll be 28. Deadly weapon means?
No objection.
29. That's 29. State is not required to have recovered the deadly weapon.
No objection.
That will be given as 30. If more than one person commits a crime,
No objection.
that'll be given as 31 to constitute the crime charged.
No objection.
That'll be given as 32. Defendant is presumed innocent.
Can we slow down just a little bit? You're faster than my fingers.
I just wanted to make sure we took out this one word. Okay, no objection, as revised. 33?
Oh, that'll be given as 33.
Yes, sir.
You guys have met and conferred about that and come up with this.
Yes, we took out the word material pursuant to the Burnside case.
That's correct.
Okay, perfect. You're here to determine if defendant is guilty.
This was an instruction that the defense offered a revised version and the state agreed, so.
So this will be given as 34 as
Thank
modified. The evidence you are to consider in this case,
No objection?
that'll be given as 36.
No, 35.
35, Judge.
Thank you. That'll be 35. It is a constitutional right of the defendant. He may not be compelled to testify.
No objection.
And to be clear, you are requesting that?
Yes.
Okay, that'll be given as 36. You heard evidence regarding drug trafficking, federal convictions, and gang affiliation. This is our Tavares instruction, correct?
Correct.
Okay, that one will be given as 37.
And Your Honor, just for the record, similarly to some of the other ones, Ms. Panduct asked us to revise it a little bit, and we agreed to her revisions.
Okay, perfect. Thank you for putting that on the record. The next one is a proffer agreement is a contractual agreement between a sovereign and a defendant that obligates the sovereign and the defendant to its terms.
Your Honor, we discussed this. My concern was with the word sovereign, that the jury may not understand that. And so there was some discussion about changing that word to jurisdiction or government, but.
How about like a specific government entity? Is that better, or what? I mean,
I don't know if the court has a similar concern.
Sovereign always reminds me of a sovereign citizen. Which
I know.
You can use whatever term, like a specific government entity.
Okay,
I think that would be better.
all right. So if you guys want to replace the word sovereign with specific government entity, it does. So it would read: a proffer agreement is a contractual agreement between a specific government and governmental entity and a defendant that obligates that government entity and that defendant to its terms, wherein both sides of the contract expect the benefit in exchange for entering into the contract. It does not bind any other government entity. In this case, you have heard that the defendant entered through. Do you want to spell out counts through?
Oh, yes, it should be spelled.
Instead of like a drive-through at McDonald's, like the actual way the word is spelled, guys. All right. Through counsel into an agreement with the United States government, the state of Nevada is not bound by that agreement. So there's no objection to that with the replacement of the word sovereign.
Yes,
Okay,
that is.
I'll give that one as 38. A statement need not made by the defendant himself to be considered his own statement.
No objection.
That will be 39. Statements defendant made during a police interview. That is,
Okay.
This is going to be 40. We have discussed it, your prior objections stand, but ultimately your request for instructions on voluntariness are acknowledged and given.
Thank you.
All right, and then the next one,
Just for the record, the state does.
and the state objects to the giving of them, but got their wording.
Correct.
Okay. So that was given as 40. And then the next one is in the same vein, in making a decision about the voluntariness of a confession or admission. This will be given as 41 pursuant to our previous argument. The next one is where independent evidence establishes.
Let me read this more carefully.
This is the corpus one. We called it corpus, but I disagree. It's really corpus.
call it the corroboration one.
Corroboration instruction, let's call it that.
Our objection stands.
Okay, but you agree that's what we
That's the
decided
wording
on?
that the court decided on.
Okay, so that will be given as 42. Previous objections are noted. The next one, wherever there is slight evidence that a conspiracy existed.
Okay, I usually put this one earlier, but let's just keep it where it is. Okay, 40, no objection.
That'll be 43. In deciding the facts, you may have to decide which testimony to believe.
No objection.
This will be given as instruction 44. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness.
No objection.
That will be given as 45.
Wait, hold on.
Although you are to consider only the evidence in reaching a verdict, you must bring your common sense.
No objection.
That will be given as 46. During this trial, you received certain audio recordings.
No
And
objection.
It explains that the audio recordings are the evidence as opposed to the transcriptions, which may contain errors.
No objection.
That'll be 47. The next one is you may not discuss punishment.
This is one that I asked for alternative language to be used and the state agreed.
Okay, so as modified, it will be given as 48. When you retire, you must select a foreperson.
No objection.
That will be 49. In your deliberation, you desire to be further informed on any point of law.
Objection.
This is the playback, so
Hold on, so 50, no objection, and then 51.
we need the instruction in there that the jury is not to test any theory of the case, etc.
Oh, yeah, I always forget that now that there's a court rule for that, so maybe we should add that before 51,
Okay, let me pull up.
or make it 51.
Let me pull up the ones that I've used for previous cases.
Wait a minute, hold on.
Oh, okay. I'm realizing at this point that we're missing ones.
I feel like we're missing one too.
We are, and she's grabbing it. It's the one where they're not supposed to do any research or look on social media and all the other stuff that the court requires us to do.
And I haven't finished with going through them, but I realized at that point that we were missing that one. The Bowman instruction.
Which is gonna be 51. I'll add it as naturally. Page break. I think the court typed that one for me in our last trial. Let's see, Aubrey. I have to bring up bad.
Please don't mention that right now.
Using that one.
Oh, those instructions work great.
Yeah, where is that one?
Ask him. Hey, you guys, do you guys have the credibility instruction in there?
Yeah.
Yeah, it's the lengthy one, it's not the short one.
All right, so the
Okay,
Bowman
we wanted the
instruction
short
needs
one
to be
in there.
given, which states, during deliberations, other than deliberating with each other in the deliberation room, jurors are not to communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. Read, watch, or listen to any news or media accounts or commentary on the case. Do any research such as consulting dictionaries, using the internet, or using reference materials. Make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on their own. Any objection to that wording of the Bowman instruction? I think
Which
that's...
instruction is this?
It's the instruction from...
Which number though?
It will
I'm going
be
to have to add
51.
it in. We don't have it. It's from Bowman versus State. In 2016, the Nevada Supreme Court indicated it was... First of all, that I had to read the admonition that I do every single time they leave the
Could you
room.
restate it? I just noticed a
Absolutely.
missing
Yes.
instruction that I thought was in there.
Okay, during deliberations, other than deliberating with each other in the deliberation room, jurors are not to, 1, communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. 2, read, watch, or listen to any news or media accounts or commentary about the case. 3, do any research, such as consulting dictionaries, using the internet, or using reference materials. 4, make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on their own.
No objection.
Okay.
And what number? That's
We could just make it 51.
And then I'm emailing it to you, Mr. DiGiacomo.
Oh, I just, the beginning of the one we used last time was slightly different, so it's during deliberations, just read me that and I have it in here already.
During deliberations, other than deliberating with each other in the deliberation room, jurors
Deliberating
with each other
other
in the
deliberation
room,
comma,
jurors are not to, colon,
are not to.
do
Okay,
all the things. Okay, so that'll be 51? Is that the idea?
and then the
That would
last
make
one will be
sense.
52.
Yes, so we'll put the Bowman instruction as 51, and then 52 will be, now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict.
I have just
and that would be 52.
There was an instruction that was omitted from these, so the state presented a different credibility instruction.
Okay.
But I thought that this one, which is a stock instruction, would be included, and I see now that it is not. It's the credibility or believability of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to have observed the matter to which he testified, the reasonableness of his statements, and the strength or weakness of his recollections. If you believe that a witness has lied about any material fact in this case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. That is a stock instruction.
Any objection to using that instruction as opposed to the one that you've included? It's
At 44, if you want to replace that in 44, I have no objection to
Okay.
that.
And I also don't mind using both of them.
Well, I mean,
We need
there's
one.
duplicative, we need one, so if you want to
If
use.
that's your request for that instruction, Ms. Pandek, that's the one we'll use.
Thank you.
If you want to just give that wording to Mr. DiGiacomo. Or he has
I
to
actually
type it
can
up.
get it
Can you
because
get it?
what
It's the one
happens,
he's used
what
in
happens
every,
is the court.
he's used that in every other trial and objected to this one, but today he decided to switch it up on me, so
Yes,
I'm
glad I
understand. You're fine. Okay.
just because I stole these instructions from ones you made me do last time, so I'm like, I'm not even gonna fight this time. How the ability of a witness should be determined by his manner upon the stand. His
Oh, okay, so while he's working on that, the state has proposed the verdict instruction, so, the verdict form, so I assume they have no objection to it. Ms. Pandek, any objection to the form of verdict?
Mr. Sampt had requested that not guilty be listed first. I told Mr. Giacomo he did not agree.
We object.
In general, in most cases, I have no objection to doing it that way, but because of the way that the step-down instruction works, it makes sense in homicides to have it in this order. And so I understand the objection and I understand why it's been upheld multiple times going in the descending order. Essentially, it converts the step-down instruction to a step-up instruction, and so that's generally why I don't do it in these cases. But all right, so, other than that objection, the crimes included are the crimes you're requesting to be included?
Yes, we did not request a voluntary manslaughter to be included.
Okay. That's on record. All right, Mr. DiGiacomo, then, do you have everything added to yours?
I'm still typing that, Judge.
Okay, perfect.
But as soon as I do, I will send it to you. Material in the case you made regard entire test of that witness or any portion of his testimony which is not proved by other. Okay, I think save as, final numbered, and I can send this around to everybody.
Okay, sounds good. Anything else we need to address while we have this time before we do closings on Monday?
We'll be at 9 o'clock as opposed to 9:30?
We hope.
I think the idea is we're having everyone get here at 9, but if we ultimately start a little later, that may be what ends up happening. But I also have to read instructions, which takes about, well, with 52 instructions, we're thinking maybe 20 to 30 minutes. So I don't think that we would be starting actual argument until about 9:30, at least. Mr. Sam?
I'm sorry, Judge. I don't remember in this department, do you give each one of them a copy of the instructions to follow along with?
So what I do is I read the instructions to them and tell them to write down the ones that they want, and then we give like 6 copies in the back.
I see. All right.
Okay?
Thank you.
Anything else?
Nothing from the state, Your Honor.
Nothing from defense?
No, Your Honor.
All right, we'll be in recess. We'll see everyone back on Monday for closing arguments. Thank you, everyone. Have a good weekend.
Thank you.
You can have this back.
All right. Well, the jury instruction discussion officially wrapped up, and now we are on to closing statements, which start bright and early on Monday morning.
Yes, the jury having a lot to think about in their time since the defense rested on Thursday. They have Friday, Saturday, and Sunday to think about how two Metro Police officers outside of Suge Knight's Las Vegas home saw a white Cadillac follow Tupac Shakur outside of his home. And during the interim, while the jury was hopefully having a day back at the office or living their life, which has been upended for now 3 weeks, lawyers doing what they do best, arguing.
A lot of more arguing, I think, than we've seen throughout the trial.
Well, leave it to me. In the time leading up to it, I assured our audience that on 8 News Plus, on our wall-to-wall coverage in Nevada versus Keffe D, Duane Davis, accused of orchestrating the murder of the rap icon here in the streets of Las Vegas in 1996, that this would be, there was nothing to see here. That it was important. It's an important stage for the lawyers to get through what they want the judge to explain to the jury with regard to the law in considering the facts that were presented in evidence of this case. But of course, I was wrong, and it was interesting.
It was actually pretty interesting. A lot of legal wordage, if you will.
Especially if you want if you've been watching the whole time and you heard all of Keffe D's many statements. Kyle Payne and Sasha Loftus joining you here until the top of the hour. Sasha, I'm cutting and pasting for you here.
Oh, thank you.
Okay, all right. And then, and so here we have a lot to talk about. And in doing so, let's start by saying that the attorneys have a job to do. They have to convince the judge that what their version of how the facts should be considered should be what the judge reads. And it wasn't Michael Sanf today. It was his associate and the two prosecutors you've seen throughout the duration of the trial.
Michael Sanf was there, but he wasn't
Yes, he didn't do the bulk of the arguing. In fact, for the last several minutes, he was sort of standing up and listening, and he seemed amused by
taking a break. I guess.
Look, he worked hard. He worked hard, and I will say, I think with absolute objectivity, that he did his job in presenting those three witnesses yesterday, because the evidence that there was two officers that said a Cadillac left Suge Knight, the founder of Death Row Records estate, behind the BMW that he and the rap icon Tupac Shakur were in the moments leading up to his murder, to Shakur being shot and killed in cold blood by someone who witnesses said was in a white car. That Edie Amin, the rapper who was in the Outlaws with Shakur, said that he saw a white Cadillac. So now a jury left to consider, what are the chances that there are two white Cadillacs in the same orbit with this rap star in the minutes before his death?
Yeah, like we said, reasonable doubt was objectively planted.
Sown, absolutely.
By the defense. Absolutely.
And especially where you have these two police officers who have no reason to have known 30 years ago when they wrote the report that a white Cadillac would come up in the eons over the time of the investigation. So the first clip we are going to go to is a long one, but this is where we're at in this trial, where the closing arguments and the jury's attention is going to be on the many times Keffe D sat down with law enforcement, sat down with film crews, sat down with a ghostwriter, and discussed his involvement, or the extent to which he was involved in the shooting of Tupac Shakur. So this is a tremendously for how tame jury instructions can be when it's just the lawyers. Keffe D wasn't even in the room. He opted not to do it. There was no presentation of evidence, nothing that he needed to. He's able to confront his witnesses, the people who testify against him.
Tupac's family was still there, though.
Yes.
That's important to note.
Yes, but Keffe D was not there. And so the attorneys, however, they earn their money in soundbite 4, I think we're calling this one. D?
A defendant's statements essentially, if believed, kind of borrowing that phrase from Gaxiola.
Okay, yes. If believed, that is fine. I think that's fair. They don't have to believe it. I'm not trying to communicate that. I'm saying they don't have to believe it, but they don't have to corroborate it.
The defense still believes that also in West, it says corpus delicti must be established before evidence of a confession or admission may be considered to prove that the accused was the criminal agency that caused the victim's death.
Yes.
So the defense maintains this is a question of admissibility, not a question of fact for the jury. It doesn't apply and should
You've
not be
just
given.
stated that in order to get into the statement, you have to show that a crime has been committed. And the state did that because we have a body. That's literally the corpus. So a corpus is beyond approved, right?
Correct.
So
We didn't raise
Brookie West is totally different because Brookie West, there's no body. And so how do we know that it's a crime? Those are all the issues. Here we have a body. Always had a body.
I know, but I don't think the instruction should be given because it was not an issue in this trial.
Corroboration.
You admitted the confessions. This would be an issue to keep the confessions out of the jury's hearing. But here, they got to hear all the confessions. So now we're infringing upon the right of counsel to argue their case in front of the jury and the right of the jury to make the decision, the duty of the jury to make their decision beyond a reasonable doubt. This instruction should not be given at all.
So talking about corpus delicti, essentially it's Latin for the body of the crime, meaning there has to be a body established, there has to be a crime before a person can be convicted, which they were, saying that, of course, that has been proven.
Yes, and it was one of many little sparring matches between defense and prosecution, the majority of which, though, as I tried to explain before playing you the wrong soundbite, was that we were there was a lot of discussion given to the statements, and that is soundbite C.
What Mr. Saft told the jury in his opening statement is, you have to corroborate what the defendant says. That is not the law. So the question is, when we talk about what's clarity to the jury, what is the law? The law is we have to prove when a person gives a confession, absent their confession, we have to prove, one, that a person is killed, two, by the criminal agency of another. But what Sefton says, and what even Ms. Panduk's case says, and I'll get to why that's inapplicable here, but what even Ms. Panduk's case says is that once you've established there's a crime occurred, you don't have to corroborate any other aspect of a defendant's statement. Now, of course, they can give it to whatever weight they want. But
Isn't that the inverse, though, of what a corpus argument would be? Is that there is only a statement and nothing to back it up.
Yeah.
You're kind of inverting it.
No, this came up specifically in Sefton. In Sefton, specifically what happened was there was a dead body, the person confessed to the crime, and what the defendant argued is, well, you never independently corroborated my other statements connecting me to the crime, therefore it's a corpus issue. And what the Nevada Supreme Court held is that there's not a third prong to corroboration. There's one, death, two, by criminal agency, three, what the defense had proposed, and what Mr. Saft has proposed to this jury specifically is that the third thing you have to do is corroborate that a defendant's statements connecting himself to that crime are true. And I don't think there's any credible argument to say that that's not what Mr. Saft said. I mean, it's a direct quote from his opening statement. But that's not the state of the law. And what Mr. Saft, when Mr. Saft makes a argument that is an inaccurate aspect of the law, increasing our burden, we are entitled to an accurate statement of the law. And what an accurate statement of the law is that we do not have to corroborate anything beyond the corpus delicti. That is the corpus delicti rule, is that we don't have to corroborate anything beyond that. And so the question for this court is Mr. Saft, because he's certainly going to say it during his closing argument, and he said in the opening statement, is Mr. Saft allowed to give a false impression about the law to the jury? And the question of that should absolutely be no. Because in the absence of anything, with the absence of an instruction telling them that we don't, that the corpus delicti rule is that we don't have to, and even if you don't want to call it the corpus delicti rule, the rule is, regarding confessions, is that we do not have to corroborate anything beyond person being killed and the criminal agency.
So you might have to explain that a little bit more, Kyle. There was a lot of legal jargon in there.
Sure.
But from me, what I got from that was that he was talking about essentially whether or not the confessions that were presented need corroboration, need another facet essentially for proof.
Well, what I see there is a prosecutor trying to make sure that he's given some cover for something that the defense attorney said in his closings. If we go back a little while to the first day when the attorneys gave their opening statements, Michael Samp, the defense attorney, said, "My client is full of bleep." He said, "My client is full of crap. You can't believe a word he said. And what your job to do is to see if they have one way to double or to back up what Keffe D said in his many statements." And that's what he keeps talking about corroboration. In that long clip, when you're hearing names you don't recognize, those are the names of cases that have been decided that the court needs to consider in doing this. But the bottom line is, Michael Samp, the defense attorney, said, "You're going to hold this prosecutor to finding out whether he can prove anything that Keffe D once said in many of his statements." And that's what we've been holding on to here as pundits or, people who have been sitting here watching. And we know, informally that they didn't, that they really didn't, that they didn't put Keffe D in the white Cadillac, if there was one.
Yeah.
They didn't put Keffe D in Nevada.
Cadillac.
Right.
That's another part of
They
it.
didn't. Well, there is direct evidence of the white Cadillac in Edie Amin's testimony. He is an eyewitness who saw.
I mean, outside of eyewitness testimony, there wasn't, photos of it or anything like that.
Right, and so we have. So now the prosecution is saying, well, he can't put that burden on us. It's not our burden to corroborate what he said. His statements alone are what we need to prove to say he did it. And so you have a legal argument based on that, whether the jury should hold the prosecution to the standard that Michael Samp in his opening statement said they should hold him to. And then the prosecutor there saying he's obviously going to argue in his closing the same thing. They weren't able to give any direct evidence that said he was the shooter other than his own statements. And the prosecutor saying, "Judge, I want you to say to the jury, we don't have to do that. His statements and his statements alone are enough to put him away." And that, Sasha Loftus, is the big question. Will the jury find that all of those statements are enough?
Yeah.
And here's the thing. There's only one count. So the jury instructions will be a little bit shorter. They only have to describe the elements of murder. Voluntary manslaughter is not on the table. This is an all or nothing game. This is a zero-sum endeavor for everybody involved. Keffe D is either going away for the murder of this fellow for the entirety of his life, or he's not, or he'll walk out of court a free man. And I just think the 3 days from the time the jury left the building until they come in Monday for closing arguments, what they're left with is two things. One, the introduction of a white Cadillac that followed Tupac Shakur's BMW, Suge Knight's BMW that Tupac Shakur was murdered in, out of Suge's estate, his gated community, and another detective who said, "I had this guy. I believed this was my guy," and the district attorney back then told me to stand down. And Michael Samp got this detective who clearly wanted to hook the murder on this guy, on Keffe D, Duane Davis, to say that he was unable to corroborate anything he said in those meetings. Couldn't find the gun. Basically, by that time, most, if not everyone, was dead. Everyone now, except for Keffe D and Suge Knight, are dead. Suge Knight, one of a handful of people who we didn't hear from in this trial.
Yeah, we also didn't hear from the ghostwriter, which I thought was interesting because
We
I believe
didn't hear
he was
from-
on the witness list in the beginning.
Yes,
one of
and he
200.
he would have been a good person to talk to say, "Hey, who wrote this book? You're under oath, sir. You're under oath here." We talked a lot about these statements that he gave. Greg Kading was the detective from the LAPD in those interviews. He wrote the book on this stuff back before Keffe D wrote his own book, and he alone said in these interviews that Keffe D this proffer would never see the light of day. Well, many years later, here in the courtroom in Las Vegas, downtown in the Regional Justice Center, we heard all of it. And it's what the jury's going to consider. So an interesting, hour and 40 minutes of testimony here on day 10 of Nevada versus Duane Keffe D. Davis, the Tupac murder trial, Sasha. Monday closing arguments.
And those will I would think last at least a few hours,
I think
depending on. I mean, opening statements lasted quite a while. So
Yes, and there are a few rounds of closings in addition to the judge reading those jury instructions, which takes a little while, and then of course the jury needs to settle. They need to pick a foreman. They need to pick who the alternates are, and the 12 people who will ultimately deliberate the future of Duane Keffe D. Davis in the Tupac murder trial, of which you are watching wall-to-wall coverage on 8 News Plus. Sasha Loftus and I will see you with 8 News Now investigator Vanessa Murphy, who is in the courtroom today and every day and providing live reports on our broadcast news station, 8 News Now. We will see you for our wrap-up show at 7 p.m. Thanks for watching.